All rise. 14A District Court for County of Washington, State of Michigan, now in session. All those having business before the court are near. The Honorable Judge Davis. You may be seated. Ms. Valdez.
Good morning, Your Honor. Ashley Lonnie Feltus for the people. Your Honor, at this time, people waive any conflict between this honorable court and the Office of the Public Defender. People do not believe that any conflict exists, but do make the waiver for the avoidance of all doubt.
Okay, the only question I have for you, are we keeping both names or are we just doing one? Because I just need to know. I mean, I had to practice and I did well.
During the transition period, it seems to be helping to use both so everybody can kind of get used to the new names.
What transition? Okay, we're good.
Thank you, Your Honor.
Ms. Page.
I like both names.
Thank you for putting, yeah, go ahead, that's fine.
I have to share my opinion. Assistant Public Defender Natalie Pay on behalf of Public Defender's Office, Your Honor. Likewise, our office does not believe that conflict exists between this court and our office, but if one were to arise, we would waive such a conflict.
Court for its part also does not believe that there's a conflict either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the people of the state of Michigan versus Jennifer Wallace.
Ashley Feltus for the people.
I have not spoken with my public defender before this. Is there a way I can speak with?
That is true. Assistant Public Defender Lauren Parody on behalf of Ms. Wallach. Ms. Wallach, I've applied to come meet with you, but I have to be approved by the facility. So my paperwork is in, I just have not been approved yet.
Okay.
So, Your Honor.
I'm due to be released on the case I'm sitting on in 3 days on Saturday morning.
In 3 days?
Yes, sir.
Fantastic.
So I was hoping for possibly a PR on this and another court date so I can talk with the public defender.
I concur, Judge.
She could have done this herself.
I know, I think so.
I'm sorry. Thank you.
No, it's okay. You got it. You're good.
I'll just ask you, Ms. Wallach, when you get out, call the public defender's office and update your contact information.
That's fine.
Okay, no problem.
All right, I'll adjourn your matter to November 5th, 2025, 9 a.m. or as your invite indicates. Bond will be reset. Hearing no objection to a personal recognizance, $1,000 bond. Thank you, ma'am.
Thank you, Your Honor.
Thank you.
Thank you.
Have a nice day.
Court does call the case, People versus Mohammed Dayan.
Ashley Feltus for the people.
An Assistant Public Defender Natalie Pate with and on behalf of Mohammed Janet, who is present. There he is. Sir, can you please state your name?
Mohammed Janet.
So, Your Honor, I'm asking an adjournment for 2 reasons. Similar to the last situation, my paperwork has been in and my approval has been pending for a little over a month to visit with Mr. Jan at the facility. I did reach back out to them this week to ask for an update as to that goes. I was provided with a phone number to speak to Mr. Jan this morning, which I did call and was able to speak to a front desk person who did transfer me. That phone number then rang for 2 minutes and then disconnected. So I was unable to actually speak with my client as well this morning, sir. So I do apologize for that. I made every attempt I could. I know his out date is some years out, so I'm just asking for an adjournment.
I would like to address the, may I address the courts real quick, please?
You are. Go ahead.
I was just gonna say, I haven't spoken to my lawyer since my last adjournment on August 6th, and I was just trying to say, I'm at this facility now, so if y'all don't have the addresses, they could give it to you. I never got no mail, and I wanted to be able to talk to my lawyer in the breakout room because I don't want to adjourn it.
Well, I'm not going to give you a breakout room. Your counsel just explained everything to the court. I'm going to adjourn it to November 5th, 2025, 9 a.m. She's trying to get in touch with you at the facility.
I want
All
to
right.
request for a speed trial. Can I say that on record?
Okay, that will be considered. I'll wait for the written motion.
Thank you, Your Honor.
Thank you.
Sir, we'll be in touch.
Court does call the case, People versus Lawrence Peck.
Ashley Feltus for the people.
Your Honor, Joe Simon on behalf of Mr. Peck making his way to the podium. State your name, Larry.
Lawrence Peck.
All right.
Your Honor, we have 2 reasons to be here today. One is the violation and the court's amended order Before we get to that, I will tell you that Mr. Peck, as you may remember, was being screened for acceptance into the 15th District Court Sobriety Court. He is going to enter that court. There's a little bit of transition with the probation agent in that court. There's a new one coming in and Ms. Johns is retiring. We hope to resolve this case and his PCC before you on the 23rd in combination to effectuate that revamp.
Okay.
So I think what Ms. Feltus and I talked about is adjourning this pretrial till November 5th, which would probably be moot anyway after the 23rd.
Got a correct statement, Melissa?
That is, Your Honor, there's a pending attempt, resisting or obstructing that arises out of the same incident, so.
Well, I'll adjourn the pretrial and bond violation to November 5th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you.
Thank you.
Okay.
Court calls case People versus Michael Heed.
Ashley Feltus for the people.
An arraignment.
Yes.
Thomas Heed, for the defendant who's approaching, Your Honor.
Your name, sir?
Michael Heed.
What's the relationship?
He is my older brother.
Okay, well, welcome. All right.
We're here for an arraignment and pretrial,
Yes.
Your Honor.
As to the arraignment, you waive formal reading, stand mute.
Yes, Your Honor, we do.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea on his behalf. All right, where do we want to go?
Your Honor, we are, of course, as the court stated here for the agreement, if you think correctly, we had discussed adjourning this case to see if we can work it out short of it.
Yes.
Will November 5th be a good date for you?
I'm here all the time.
Okay. Yes, November 5th will be a fine date, Your Honor.
I'll adjourn this then to November 5th, 2025. 9 a.m. As to bond in this case, I will set his bond at $5,000 personal recognizance bond, standard conditions, including no assault behavior or possession of any weapons, no alcohol, recreational marijuana, or any illegal drugs. You understand that, sir?
I do, Your Honor.
Is there any reason that for you? The no-go to is going to be a bit of a difficulty only because you live on Clark Road.
I do, Your Honor.
So what I'll do is you're not to go to or enter the Clark Road address, the 40.
Your Honor, he lives there.
I just said that.
Okay.
If you let me finish.
Okay.
I'm going to say apartment 313.
Okay.
All right. Thank you. Was there a no contact that you wanted or no?
Yes, Your Honor.
All right. With,
It's on the bond.
is it?
Erica Hogan.
I'm sorry.
Erica Hogan, ERIKAHOGAN.
We have that on the mount one. Put it on this side. They did. Can you get that? This one. No contact with Eric. And not to enter IDD address for this apartment 313. All right. Okay.
Thank you, Your
Thank you.
Honor.
Thank you.
Court does call the case People versus, is it Sudhil Singh?
Ashley Feltus for the people.
Good morning, Your Honor. Joseph Wagner on behalf of Mr. Singh, who was, state your name.
Sukhdal Singh.
Your Honor, we're here for two reasons today. One is an arraignment, and we waived the reading. And I'd ask you enter plea of not guilty for my client. And we understand there's a pretrial that I've spoken to the prosecutor, and we've agreed to adjourn it until the 5th of November.
Defendant having waived formal reading. This is, my stickers are all out of order, folks. Defendant having waived formal reading. Asking that a not guilty plea be entered. I'll enter that not guilty plea. Pretrial in this matter will be adjourned to November 5th, 2025, 9 a.m. The bond in this case, bond will be set at a $5,000 personal recognizance bond. Order standard conditions, including no assault behavior, possession of any weapons, no alcohol, recreational marijuana, or illegal drugs. I will also indicate at this time he's not to enter any Sam's Club in the state of Michigan. All right. Thank you.
Thank you, Your Honor.
Court calls case People versus, is it Bella? That's a lot. Is it Live?
Ask those for people.
Good morning, Your Honor. Alexander Homnowski with and on behalf of Vessel Leo. Your Honor, this is time and date set for arraignment pretrial. With regards to arraignment, we waive formal reading of the charges and stand mute at this time.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Go ahead.
With regards to pretrial, we've come to an agreement. The plea form has been submitted.
I haven't, and it indicates defendant would be pleading to, is he pleading guilty or no contest? Because I don't have the box checked.
And we're going to be
Pleading guilty to the charge of retail fraud in third degree, the 93-day offense. Upon his successful plea to that charge, count one would be dismissed. There is an agreement that the prosecutor will recommend HIDA. That's the court's full understanding of the agreement.
That's correct, Your Honor.
Okay, having sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Vessel Leo.
All right. Sir, it is this court's understanding you're going to plead guilty to the charge of retail fraud in the third degree. That is a misdemeanor punishable by up to 93 days of jail. $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that becomes the maximum fine. You understand that, sir?
That's Your Honor.
All right. Understanding that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of rights.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
because you, and also because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
On the date of February 24th, 2025, at the location of 3749 Carpenter Road, Pittsfield Township, Washington County, State of Michigan, what'd you do at the Target that makes you think that you're guilty?
I took stuff that did not belong to me.
You went into the store, you took stuff and tried to walk out without paying for it?
Correct.
What kinds of things?
Miscellaneous dorm items.
Be more specific.
I guess there was bedding.
You're a student
Correct.
and you were taking stuff for your dorm room?
Correct, Your Honor.
Store was open to the public at the time?
Sorry?
The store was open to the public at the time?
Correct, Your Honor.
You didn't have anybody's permission to take that property, did you?
Yes, Your Honor. Or, no, Your Honor, sorry.
And let's make sure we have that.
Yeah.
You didn't have anybody's permission to take that property, did you?
No, Your Honor.
All right. And the property you took was property that was offered for sale by Target?
Yes, Your Honor.
Sir, I do have to advise you that if you commit misconduct as defined in the Michigan court rule between the time of my acceptance of your plea and the time of your sentencing, that you would not be entitled to the court would not be bound by any sentence recommendation. And the court would not be bound by any evaluation. You understand that?
Yes, Your Honor.
You understand also that we're committed that you would also not be entitled to withdraw your plea.
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And has the court complied with the court rule?
You are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2, retail fraud 3rd. Count 1 is dismissed. Pre-sentence investigation is ordered. Defendant is referred to probation. Pre-sentence investigation and report. Sentencing in this matter will be November 12, 2025, 9 a.m. Instead of 9 a.m. 9 a.m. or as your invite indicates. As the bond in this case, I'll set his bond at a $5,000 personal recognizance bond. Standard conditions, including no assaultive behavior. There's to be no use of alcohol, recreational marijuana, or any illegal drug. You understand that?
Yes, Your Honor.
I'm also going to indicate at this time you're not to enter any Target store in the state of Michigan. You understand that?
Yes, Your Honor.
Your Honor.
Thank you. Court does call the case People versus Brandon Bovee.
Ashley Phelps for the people.
Your Honor, David Shan, behalf of Brandon Bovee. Brandon, can you please state your next order?
He did.
Way ahead of me.
Shan, you were hiding on that side. You know something? You're never on that. You're always over there somewhere.
I've been trying to go on the side of justice and light, Your Honor, so under
Wow.
this side is a
No, I'm not even going there. Go ahead. Did I said anything?
tentatively, he is accepted into Lenawee County Treatment Court. He needs to get screened and assessed by their treatment team to make sure that he's qualified. I did actually talk to Judge Shadler yesterday, so it looks like it's going to be something that we can do, but he has to go through the process. And I understand the next date is the 5th of November, which is 3 weeks. I don't know whether that's enough time to get screened
That's what I
and
was gonna-
assess the treatment team, meet, recommendation made and acceptance happen.
What's my next date after that?
November 19th.
19th will be fine.
And there's something I need to talk to Mr. Shand about as well, Your Honor, so thank you for the 19th.
All right. November 19th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, sir. Court calls the case People versus Salvatore Lorenzo.
Ashley Phelps for the people.
Good morning, Your Honor. Sam Bernstein with and on behalf of Sal Lorenzo. Bless you.
Bless you. Your name, sir?
Salvatore Lorenzo.
Thank you.
Your Honor, we do have a plea resolution to put on the record today. Hopefully the plea form is in front of Your Honor.
It is. What's he pleading? Is this guilty?
Guilty, Your Honor.
So. All right. I have here that the defendant will be pleading guilty to count 2, attempted resisting and obstructing a police officer. That's a 1-year offense. Also count 3, operating while visibly impaired, the 93-day offense. Upon his successful plea to those charges, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's correct, Your Honor.
Yes, Your Honor.
Sir, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right. State your name again for the record, please.
Salvatore Lorenzo.
All right. Sir, it is this court's understanding that you are going to be pleading to 2 misdemeanor charges. The first being the stated count 2 of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
Also, that you'll be pleading guilty to the charge of operating while visibly impaired. That's a misdemeanor punishable by up to 93 days in jail, up to a
Yes, Your
$300
Honor.
fine. Up to a $300 fine plus court costs. The court could order community service or any rehabilitative services the court deems necessary. Court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that?
Yes, Your Honor.
And understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
To the charge of attempted resisting and obstructing a police officer, how do you plead?
Guilty.
To the charge of operating while visibly impaired, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
You understand that you're waiving the rights on that form as well as particularly the rights contained under paragraph 5 of your trial rights.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Has anybody threatened you or coerced you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will.
Yes.
And because you believe that you're indeed guilty of these offenses?
Yes, Your Honor.
On the date of December 31st, 2024, at the location of Packard near Oakdale Drive, Pittsfield Township, Washington County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes, Your Honor.
What did you have and how much?
I had several drinks. It was 8 months ago. I had too much to operate a vehicle.
All right, were you stopped by the police?
Yes, Your Honor.
Why'd they stop you?
I had a flat tire. I was driving on a flat tire.
You're not disputing the right of the police to stop you in this instance, are you?
No, Your Honor.
Were you ultimately arrested?
Yes, Your Honor.
Were you taken to the hospital?
Yes, Your Honor.
Was there a blood draw?
Yes, Your Honor.
Were the results of that blood draw 0.168?
Yes, Your Honor.
Do you have any reason to dispute those test results?
No, Your Honor.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, Your Honor.
When you came into contact with the police, what happened with your interaction with the police?
It was a poor interaction. I deeply regret it. I wish I would just have complied.
Okay, so what'd you do?
I was brought to the vehicle and I didn't put my leg inside the vehicle to be taken to the jail.
So they were asking you to get into the vehicle. They were arresting you.
Correct. Yep. And I didn't.
And you just didn't put your legs in and tried to basically not get in the vehicle when you were ordered to get into the vehicle.
Yes, Your Honor.
Sir, if I accept your plea, you do understand that if you commit misconduct between the time of my acceptance of your plea and the time of sentencing, misconduct is defined under the Michigan court rules, that you would not be entitled to withdraw your plea, and any sentence evaluation the court would no longer be bound by. You understand that?
Yes, Your Honor.
Counsel, have there been any other promises, threats, or other inducements which led to this plea?
No, Your Honor.
Have I complied with the court rule? Would it be proper to accept this defendant's plea?
I do believe the court is compliant with the court rule, but I would note for the record, that was not the only way in which the defendant resisted police officers that night. There was significantly more.
Significantly more? Like what?
Refusing to get out of the car, refusing all commands, refusing to get on a stretcher, refusing to put his body inside of the vehicle, refusing to let the vehicle doors be closed once he was put inside the police vehicle. I just think the court deserves the more accurate picture of what happened.
Is that correct, sir?
Yes, Your Honor.
Okay, I'm gonna just advise you one thing. Thank you, Ms. Feltes. That when you go talk to probation and when you're dealing with this court, you might as well be straightforward and truthful. Because if you're not, and I'm sure your counsel will advise you, bad things tend to happen. Are we understood?
Yes, Your Honor.
He wrote a very nice apology letter to the officers, Your Honor. He does feel quite bad about it.
Oh, I understand that. I'm sure he does. Usually when people get called to the table on something, they feel bad about it. I'm just saying he needs to be truthful and forthright with the court. Otherwise, that will be his second mistake.
Understood, Your Honor. Thank you.
Court.
And I apologize, I interrupted the ask if we were compliant, but I did thought the court needed to know.
All right.
Oh, yes, Your Honor.
All
Yeah,
right.
compliant.
Court will accept the defendant's plea. 2 counts, 2 and 3. Count 1 is dismissed. Defendant is referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be November 12th, 2025, 9 a.m. Bond will continue. Do I have probation intake? All right. Sir, hold on the line. We're going to put you in with probation intake so we can start the process, okay?
Yes, Your Honor.
Thank you. Court does call the case, People versus Brian Maynard.
Morning, Your Honor. Sam Bernstein with and on behalf of Mr. Maynard. Can you please state your name for the court?
Brian Maynard. Thank you.
Your Honor, we're hoping for an adjournment to obtain and review the discovery in the case.
The action on this matter will be adjourned November 5th, 2025, 9 a.m. Bond will continue.
Your Honor, there's one request if I could put in. Mr. Maynard is hoping to resume contact with the victim in the case. I'm guessing that I would probably need to speak with Ms. Landy offline about whether that's desired from the victim's side of things before the court can fully address it.
Correct.
Okay.
My notes would reflect no non-consensual contact disorder.
Yes.
Okay.
I think that, yes, that is what I would.
Understood. Thank you, Your Honor.
Thank you. Court calls case, People versus Wayne Rankin.
Good morning. Again, Your Honor, Sam Bernstein with and on behalf of Mr. Rankin, who's approaching. Sir, could you please state your name for the court?
Wayne Rankin.
Thank you.
And then this, Your Honor, we put in a request for a proposed resolution from Ms. Feltes Landy, and we just need a little bit of time to get there.
He just reversed the names. See, this is what's confusing.
I meant to say Landy
you
Feltes.
said Feltes Landy. It's not it.
I'm in
Is
a
it?
transition stage myself here.
Are you? Okay, that's why we need the transition. Got it.
There we go.
So, will November 5th be enough time for?
Certainly, Your Honor.
All right. I'll adjourn the matter November 5th, 2025, 9 a.m. Thank you, sir.
Thank you, Your Honor.
Tough to provide the deal. First, calls the case, People versus Renee Darga.
Good morning, Your Honor. Patrick J. Politano on behalf of Renee Darga, and this is Felicia, her sister, who's her guardian.
Okay, very good. Your name, ma'am?
Renee Darga.
Thank you. All right.
You got his time and date set, I believe, initially for an arraignment. We would waive a further formal reading of the charges and maximum penalty. My client will stand mute and ask that Your Honor enter a not guilty plea on her behalf.
Pending having waived formal reading, standing mute, court will enter a not guilty plea. All right. What are we doing?
Counselor, I'm just looking for a little bit of time to talk about the case. I apologize.
No, that's okay. Absolutely correct, Your Honor.
Just looking for some time, please, Your Honor, to discuss the case.
All right. I'll adjourn the matter November 5th will work for you.
It will, Your Honor. Thank you.
November 5th, 2025, 9 a.m. As to defendant's bond, I will set bond an amount of $5,000 personal recognizance bond, no standard conditions, no assault behavior, possession of any weapons. There's to be no alcohol, recreational marijuana, or illegal drug use. I will also be consistent. Is it Crystalline Rabago?
That's the name I have here.
Is there any reason she needs to have contact with her?
So Judge, she has moved to a new facility, but in the afternoons, they are all brought together just to work. So they would be in the same place, but I don't think that they would actually.
Gotcha. So, well, so that there's no confusion, I'll just order no assaultive behavior. I'm not gonna let people do, I'll let people do what they're gonna do.
Okay.
And if we have
Thank
to
you, Your
deal
Honor.
with it, we'll deal with it. All right. Thank you.
Thank you, Your Honor.
Take care, man. Court calls the case, People versus Eric Hopkins.
Good morning, Your Honor. Robert Ellman with and on behalf of Mr. Hopkins. Mr. Hopkins, can you please state your name for the record?
Eric Hopkins?
People are gonna be filing a no.
You are.
I am, but I haven't done it yet, but I will.
Okay. Any objection?
No, Your Honor, none at all.
I'll indicate at this time that the case is dismissed. And then I'll sign that when it comes through.
Thank you.
Thank you.
Thank you, Your
Thank you,
Honor.
Your Honor.
Thank you. Court calls the case, People versus George Walker.
Closest with people.
And good morning again, Your Honor. Robert Ellman with and on behalf of Mr. Walker, who I believe is present over Zoom. Mr. Walker, can you please unmute and state your name?
You have it?
George Walker.
Okay, I need a camera, sir.
I'm trying to get it to come up. It just keeps saying background.
Yeah, we just started using Zoom. I get it. All right, what are we? No, it's okay. You're there. I see you now.
My
Okay.
bad.
What are we doing?
Your Honor, after our conversation with Ms. Feltus, I believe we'll be asking for an adjournment. There's some additional information I think that the people need in order to make an offer and move the case forward.
That's correct, Your Honor.
November 19th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Did he say November
Court calls-
19th? I'm sorry.
Yes, sir.
Okay.
Really, man? Yes. November 19th.
Okay.
You got it?
Yeah.
Okay. And you'll know how to work Zoom if you appear that way, right?
Yeah, I got you, Judge.
Okay, all right. I'm just checking, making sure.
For sure.
All right, take care.
You too.
Court calls the case of the People versus Justin Kitara.
Good morning, Your Honor. Oscar Rodriguez with Justin Katere, who is on Zoom. Justin, can you give us your name?
Yes, Justin Katari.
Okay, thank you. All right, what are we doing?
Your Honor, we have a resolution in this case, and I hope there's a plea form in front of you there, as well as a police report. This is a no contest plea.
I don't
Dismissing the
have
initial
I don't
charge.
have anything.
The materials were emailed to your office on October 8th, along with the plea form.
October 8th?
Yeah.
Probably.
I thought they had sent over as well.
What?
I thought they had gone over as well, so I'm just trying to see.
It's October 8th at 1:49 p.m.
Well, even if we have a, is it going to be a no contest plea?
I think it had to be due to lack of recollection, Your Honor.
Okay, because I don't recall reading all those police reports were sent to me. I don't recall receiving a police report, but we were on vacation or just coming back from vacation.
Yeah, I don't know, maybe my last name is spelled wrong. I don't see anything.
You don't see anything.
Oh, I don't have.
I can re-forward that email.
You have it, Ms. Lundy?
No, I thought I did, but now I see that what I had was the progress report that Ms. Weidling had sent for this person. I was mistaken. I had sent the plea form to Mr. Rodriguez on the 6th. And he let me know that it would be entered, so I'm not quite sure what happened. I don't have a copy.
All right, so you don't have a copy of it signed. I don't have a copy. I don't know. Do I have his advice or rights? We don't have anything, so I'm going to adjourn this out to November 5th, 2025. I've got 185 cases today. I'm not going to stop to read a police report. Once we get everything, I'll take a look at it. And hopefully can take the plea on that day. Thank you. Court calls the case, People versus Charles Peters.
Good morning, Your Honor. James Mifelsky appearing on behalf of Mr. Peters, who's to my right. Please state your name.
Charles Peters.
I have before me a plea form that indicates the defendant's going to be pleading guilty to an added count 2 of operating while visibly impaired. Upon his plea to that charge, count 1 would be dismissed. That's the court's full understanding.
That's correct, Your Honor.
That is correct, Your Honor.
May I have him sworn?
Right hand. Solemnly swear to affirm the testimony. Truth, the whole truth, and nothing but the truth.
I do. Charles Peters.
Sir, it is his court's understanding you're going to plead guilty to the charge of operating while visibly impaired. That's a misdemeanor punishable by up to 93 days jail, $300 fine plus court costs. The court could order community service, any rehabilitative programs the court deems necessary. Court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
I do.
All right. Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
I do.
You signed an advice of rights form, is that correct?
I have.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
I do, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
You on probation or parole?
I'm blowing into the pro-link, but I believe that's a condition of bail, not probation or parole.
That is correct for this court.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Anybody threaten you or coerce you? You're doing this voluntarily?
Yes, Your Honor.
Of your own free will?
Yes,
And because you believe that you are indeed guilty?
I do.
August 11th, 2024 at I-94 near State Street in Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
I was.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes.
What'd you have and how much?
I had 3 IPAs. I only saw IPA on one of the cans, but I drank 3 of them, and they were not shorts, they were talls. This started at about 2 in the afternoon and went until about 5 in the afternoon.
Were you stopped by the police or was there an accident?
I was stopped by the police. After I was stopped, there was a separate vehicle that was in an accident. It was distracting for both the officer and myself, but I was not in an accident.
Okay, so you got stopped by the police.
Yes, Your Honor.
Were you ultimately arrested?
I was.
Were you taken to the hospital or police station? Or
I was
both?
taken to St. Joseph's Hospital. And
Was there a
then-
blood test?
Yes, there was.
Were the results of that blood test a .153?
Yes, Your Honor.
Do you have any reason to dispute those blood test results?
The blood test, no. I'm sorry, Your Honor, no.
So you have no, I want to make it clear, you have no reason to dispute those blood test results.
I have no reason to dispute the blood test results. The blood test was ordered after a breathalyzer, for which there was not permission asked. But the results I don't dispute.
There was not what?
I was given a breathalyzer when I was pulled over, but the officer did not ask. But the results in themselves,
Did not ask what?
To distribute a breathalyzer.
The one on the PBT?
Yes, Your Honor.
You've heard of implied consent?
Yes, Your Honor.
You know what that means? That means for the privilege of driving on these roads and having a license in the state of Michigan, you consent to taking a PBT. You understand that?
Yes, Your Honor.
I take it by your eyebrows that you didn't understand that, but you understand that now.
Yes, sir, I do.
All right, so you have any reason to dispute the blood test results at the hospital?
No, Your Honor.
All right. Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
It was.
Counsel, well, I do have to advise you, sir, that if I accept your plea and you commit misconduct between the time of my acceptance of the plea and the time of your sentencing, that you would not be entitled, or the court would not be bound by any sentence evaluation or recommendation. And also, you would not be entitled to withdraw your plea. You understand that?
I do, Your Honor.
All right. Counsel, are there any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
Has the court complied with the court rule? Would it be proper to accept this defendant's plea?
The people are satisfied.
Defense is satisfied, Your Honor.
Court will accept the defendant's plea to count two. Count one is dismissed. Defendant is referred to Von Schwartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be November 12th, 2025, 9 a.m. Bond continued. Thank you.
Your Honor, very briefly, my client has been assessed by Von Schwartz. It was last year, sometime shortly after the incident. But he's also, so I'll forward that to.
That's probably going to be stale. He's probably going to need a new evaluation.
My request is, would the court consider discontinuing the sober link at this point? My client has done about 45 AA meetings, has a sponsor, has really taken hold of the reality of the situation and made positive movement, and no positive blows on the machine, I think, for about 2.5 months.
Ms. Feltes, I know you want to say something. I'm just going to shortcut this. No. Okay. Thank you.
Thank you, Your Honor. Have a good day.
Yep, you too. Court calls the case People versus Flores Rivas.
And Crystal Marie Medina, Your Honor, good morning on behalf of Ms. Flores. Your Honor, my client does require the services of a Spanish interpreter. However, I am prepared to waive for the arraignment purposes, Your Honor. I speak Spanish fluently. I was able to go over all of her rights with her, and I do feel comfortable waiving formal reading and standing mute.
All right, I could do it in Spanish. Okay, no, I can't. I'm lying. I mean,
Nombre completo.
Dalia Flores Rivas.
Thank you. So as to the arraignment, counsel, you waive formal reading, your client stands mute.
Yes, we would, Your Honor. Thank you very much.
And then having waived formal reading, standing mute, court will enter a not guilty plea. You need a new date.
Yes, Your Honor, and we would ask if the court would be inclined to allow us to return on November 19th. I have multiple matters scheduled for November 5th, and we're hoping to work out a resolution prior to that date, Judge.
She wants the 19th because she's got other stuff to do. That's more important than coming here and seeing me.
No, Judge, I will make it work.
That's what Alan, is that what you're hearing? That's what I heard.
No, Judge. Previously scheduled.
All right. I'll adjourn it to November 19th, 2025 at 9 a.m. We'll have an interpreter available via Zoom.
Thank you very much, Your Honor. I do appreciate that.
And as to bond in this case, and I trust that you will also explain this to your client, I'm setting her bond at a $5,000 personal recognizance.
Personal.
I'll order standard conditions like no leaving the state, etc. No assault behavior or possession of any weapons.
No posesión de armas o darle golpes a nadie.
No alcohol, recreational marijuana, or any illegal drug.
Drogas, including marijuana. And not to return to Walmart, Your Honor. I believe it's.
Yes, she's not to enter any Walmart in the state.
Thank you. Y no entrar al Walmart. Ningún Walmart.
All right.
Thank you, Your Honor.
Thank you.
Thank you very much, Your Honor. It was a
Okay.
pleasure seeing you. Thank you.
Thank you. And counsel, can counsel approach on this matter?
Yes, Your Honor. Permítame.
Court does call the case of the People versus Benjamin Tetro.
Morning, Judge. Roger Cayley, P 4811 on behalf of Mr. Tetro, who's standing to my right.
Your name?
Ben Tetro.
All right. What are we doing?
Judge, I am in talks with the prosecutor. My client emailed me some documentation and I think will help resolve this case. Just need a short adjournment to get those over to the prosecutor.
The 5th work for you?
It's fine, Judge.
November 5th, 2025, 9 a.m. Bond with its conditions will continue.
Thank you so
All right,
much.
thank you. Court does call the case People versus Melissa Hatfield.
I should focus with people.
Your Honor, Tina Saxon. Or Melissa Hatfield. Melissa, state your name. Good morning, Melissa Hatfield.
Thank you.
Your Honor, I believe we're in receipt of all discoveries, so I'm asking for a final settlement conference
You want to do this Friday?
this Friday. Is that what you said?
I did, but
Um,
I don't think the people would be ready. But
I'm not sure that I can be ready by Friday. I apologize.
all right, no, that's fine.
I was this close.
Jury final settlement conference will be set for December 5th.
Yes.
December 5th, 2025 at 9 a.m. Jury selection, if necessary, will be the 8th.
Yes.
December 8th, 2025 at 8:30. Both of those proceedings are in person.
Thank you, Your Honor.
Thank you.
Your Honor.
Bond will continue. Court calls the case of the People versus Reginald Sims.
I should focus with people.
Take out my.
Your Honor, I did receive a stipend order from defense counsel requesting to adjourn this matter. I wasn't sure if it made it in before the deadline or not.
I don't think it did,
It
but
didn't- We didn't get until yesterday afternoon.
we didn't get it till yesterday afternoon, but Miss Counsel's not here.
And I don't think I replied until yesterday afternoon. I didn't get it until Tuesday afternoon.
All right, Mr. Sims is here, however.
Yes.
All right. Your counsel's filed a stipulation to adjourn this. It came in after the deadline, so it didn't get processed by us. What I will do, sir, is I'll adjourn, since you're here, I'll adjourn this matter to November 5th, 2025, 9 a.m. All right?
Thank you, Your Honor.
Thank you, sir.
One of those facilities is signed in.
Court calls the case People versus Alejandro Cervantes.
This wasn't a arraignment. Without.
Without counsel and the facility, we know that they're in custody or not,
Yes. But they're not.
but the facility did not sign in. So I'll adjourn this to November 5th, 2025, 9 a.m.
Is that a federal, is it federal prerequisites? That is fine. Okay, thank you.
Court also then calls the case, Triandis Martin.
Special focus for the people. This is also an arraignment. So we confirm it did not sign it.
On both cases.
Yes, sir.
So I'll adjourn both these matters to November 5th, 2025, 9 a.m.
Thank you, Your Honor.
We have our. That it for that block,
That's it for that.
and then we'll come up on our next block. The gentleman seated to the very back. What? Yeah, what's your name?
I'm John.
And where are you from? Okay. Is he on our docket today?
He's still listening to Eric. Yes, it's Mr. Nair, Your Honor, but he's not until a later time block. Yes, we spoke
What?
yesterday.
Pardon?
Yes, and I spoke with Mr.
Council approach on that.
We're starting, but Mr. Stiller is on too, so.
He's on, okay.
Yes.
Okay.
And it's not mine, naturally, right? That's fine.
All rise. 14A District Court for County of Washington, State of Michigan, is now back in session. The honorable day 7.
You may be seated. Do we have an hour?
We don't have that many. We're gonna run out eventually.
That's right. Court does call the case of the people versus Sean Ode.
Conrad Siller on behalf of Pittsfield Township.
Good morning, sir.
Good morning, Your Honor.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Odom Jr., who may be present via Zoom.
Do we have him checked in? Odom, not here.
So, Your Honor, I believe I might have a half explanation for his failure to appear. I was of the belief that my client was in the Washtenaw County Jail until yesterday. However, the Sean Odom in the Washtenaw County Jail is my client's father. So that being said, I did not attempt to contact my client out of custody until yesterday afternoon. His phone number is disconnected. However, I did have a good email address to which he responded asking for the court code. I did provide him with the Zoom information, I believe just this morning. Given that, and I believe it will partly be my fault, I would ask for an adjournment of this case.
Well, if it shows up, I'm willing to recall it, but this time I'm going to issue a bench warrant. Bond 10%.
Thank you, Your Honor.
Court calls the case, people versus Andrew Party.
Conrad Siller on behalf of Pittsfield Township. I believe there's two cases for Mr. Party, Your Honor.
There are two attorneys too.
An assistant Public Defender Natalie Pate with and on behalf of Mr. Andrew Party in the case ending in 1090.
Good morning, Your Honor. Charlotte Steffen on behalf of Mr. Party and the case ending in 0621.
Yes. All right. What are we doing, folks?
Your Honor, the prosecuting attorney has extended an offer or a couple of offers to Mr. Party, and I understand that he wants to accept the offer in which he would be pleading guilty in one case. The other case would be dismissed, and the one he's pleading guilty to would be a deferred sentence, if I understand the offer correctly.
That is the offer, Your Honor. I suggest he pleads in the more recent case, which would be 1090.
So he'd be pleading to the possession of drug paraphernalia.
Correct.
And I have no form on that, right?
That is correct, Your Honor. I did meet with Mr. Party yesterday morning, and he indicated he did not want to plead in my case at that time. I understand that there might have been a change in that.
So
my request in my case would be for then a brief adjournment, given that development, Your Honor.
Well, if he wants to plead, to the older case, I'm okay with that.
But the problem is that he's indicated that he didn't want to plead in that.
In my case, correct, Your Honor.
I was confused on what was going on when I spoke with her. I didn't know. I just wanted to know. I hadn't spoken with my other attorney, so I just wanted to know what's happening in both cases before I made a choice. And after I'd spoke with her,
Is he held on anything other than this?
No, Your Honor. He's held on these two cases because of the remand on the bond violation.
Oh, I know. I know why he's here on my cases, but there was not anything else he's held on. All right. So what does he want to do? Randy?
I was going to plead guilty in a case, and I was hoping to be released. All
right. So we'll then have him plead in 621. And then the other one will be dismissed because of the conversation that he had with you, Ms. Pate. That way, there's no. Probably need a form at some point, maybe not. All right. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name.
Andrew Party.
Sir, it is this court's understanding you're going to plead guilty to the charge of possession of drug paraphernalia under the Pittsfield Township Ordinance. That's a misdemeanor, punishable by up to 90 days, $500 fine plus court costs. You understand that?
Yes, sir.
Understanding that, still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind. Had you previously, yeah, that's a problem. Have you executed an advice of rights form?
He has not signed it, Your Honor. However, I did review it with him.
All right.
Would you like me to sign it now, Your Honor?
Yes.
I got a date.
Got that advice of rights form. You have any questions regarding any of those rights?
No,
You'll see on the podium, look at paragraph 5. Those are your rights which are part of a trial. You understand that you're giving up those rights
yes, sir.
by entering this plea. Does anybody promise, you understand also you're giving up your right to appeal of right?
Yes, sir.
Anybody promised you, are you on probation or parole? I'm sorry.
No, sir.
You're not? Has anybody promised you anything other than what's been stated here today to get you to plea?
No, sir.
Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily
Yes, I am.
of your own free will
All free will.
and because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
I might take it in this case. On the date of May 18, 2025, at location of Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan. Did you have drug paraphernalia in your possession?
I believe I did. Yes, sir.
Did you have a syringe and used crack pipes in your possession, sir? On that day?
It was in the, it was in the car, yes. Yes, Your Honor.
Okay, and were you in the car?
Yes, I was.
And were these items yours?
Yes, Your Honor. I guess.
Well,
That's complicated. I knew they were in the lug. I just knew they were in the luggage. I didn't take them out. So I knew they were there. It's like, yes. Oh, I knew that was there. Yeah, same thing.
Yeah, Your Honor, if I can help clarify, one, because the case of Ms. Pate involves a car, the case that I represent him on involves a hotel room. So I think he was just confused on
Confused as
when
to
you
which
said
one.
car.
They were
I
both by the
might,
same area.
may I have a word here, Your Honor?
Yes, you may.
All right. So in the hotel room, you had a bag or luggage with you,
Yeah, yeah.
and there was a syringe in your
Oh,
bag.
yeah. Yes,
Is
sir.
that correct, sir?
Yes.
Okay, and you knew it was there?
Yes.
All right. And you used that syringe for the purposes of taking narcotics of some type. Is that correct?
Yes, Your Honor.
All right. Sir, I do have to advise you if between the time of my acceptance of your plea and the time of sentencing, you commit misconduct as defined in Michigan court rules. The court would not be bound by any sentence evaluation and you would not be entitled to withdraw your plea. You understand that? Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
No, Your Honor.
All right. And have I complied with the court rule?
Yes, Your
I
Honor.
have, Your Honor.
All right. In case 621, court will accept the defendant's plea of guilty. In the other matter, that case is dismissed pursuant to the plea.
Your Honor, I can file a nollie process if that would help.
Yes, please.
All right, I will.
If you will.
Okay, I will.
Okay. And on this matter, I revoked your bond. Anything you want to say before I do impose sentence, or you want me to set them for sentence?
I have people that are in my hotel room. I went out. I've been trying to get there with all my belongings, and my anxiety's been going through the roof. I don't know what they're doing with my belongings. I'm afraid they could all be gone, and everything I own is literally there. And I would do anything if I could get there to find out they're even in my hotel room still. I got stuff worth almost to $100,000. Like I got a brand new bike.
He's just trying to ask if Your Honor will release him today is where he's going with this.
Thank you.
I got a vehicle that's sitting at this hotel. I don't know if my vehicle's there anymore.
How long has he been in? He's been in
Like 40 days, I believe. It's been over a month.
I believe it was since September 17th, Your Honor.
Yes, it is. I see it. You see it's 15. Fines and costs of $250. I'll make that due and payable by December 31st, 2025. 90 days of jail credit, 30 served, the balance is suspended.
Thank you, Your Honor.
Thank you.
Your Honor, do we need to address the bond violation? There's also,
There was a bond violation, but do you admit to the violation?
Yes, yes, sir.
I'll sentence it to 30 days, credit 30 served on that.
thank you.
All right, thank you. Yeah, can you hand wait? Court calls case People versus Sharon Abbott.
Sherilyn Foster Tucker on behalf of Sharon Abbott.
Good morning.
Your name?
Sharon Abbott.
Thank you. What are we doing?
Your Honor, we're just asking for an adjournment. I'm hoping to give the prosecutor some information, so maybe a little bit longer of an adjournment if possible.
November 19, 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
Thank you. Court calls the case of the People versus Jacqueline Murray.
People.
Edward Driggs for Jacqueline Murray.
Jacqueline Murray.
Thank you. What are we doing?
Your Honor, I'm asking just for a brief adjournment.
November 5th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls case People versus Mutada Al-Khalaf.
Ashley Phelps for the people. Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. El Kalfa Murtada. Yes, hold on. Take it out.
Can you state your name, please?
Murtada Al-Khalaf.
All right, you need to turn a camera on, please. All right, thank you.
Your Honor, we are requesting an adjournment. My client has
Go ahead.
an appointment at Secretary of State on Monday to
On Monday.
get his license. Yeah.
Oh, to get the whole license, you think?
Well, actually,
Or does he just starting a process?
I should clarify, yeah. Do you know if you're gonna be receiving your license on Monday or just they're gonna tell you what you need to do to clear it up? I can't remember, I apologize.
Give me some information on what I need to do.
They're gonna be giving you some information on how to get your license? Is that what's happening?
Yeah. So I'm still waiting
Okay.
on what they say.
November 19th, 2025, 9 a.m. We'll try to figure out where he's at that point. Okay? Thank you.
Thank you.
Thank you, sir. Court calls the case People versus Deanna Conrad.
Conrad Siller on behalf of Pittsfield Township.
And Ashley Phelps for the people.
Assistant Public Defender Natalie Pickerton on behalf of Ms. Conrad, who is approaching. Please state your name for the record, ma'am.
Deanna Conrad.
Thank you.
Thank you, Your Honor. Today's the date and time set for a pretrial hearing, and I'm also prepared to address the bond violation, if the court would prefer to start with that.
Yes, wait a
Thank you, Your Honor. So I did receive the violation report, I'm sure the court is in receipt of, where my client
Go ahead.
My client did test positive or did consume alcohol while on bond.
Yes.
She admits that both to community corrections and to me, and she does admit the bond violation today. When I did initially get this report and speak with Ms. Conrad regarding the violation, she was immediately forthcoming with me. I did then advise of the warrant, and then she did, under my advice, turn herself in on that warrant this morning. She does take full accountability of the fact that she did consume alcohol and does apologize to the court. She is asking if the court would consider releasing her today, given the fact, and she does recommit to her sobriety and acknowledges to me that she will not consume any further alcohol while on bond. This is a case from 2018. My client does have full-time employment. She works as an inspector for Real Truck, and she is hopeful.
But she didn't even, hold on, I mean, I'll listen to you. Really? That's like the fifth time. What? No, I mean, bless you. That's a, I meant to say it that way. In this case, she was a 2.55 and a crash. And so while you're talking the time between when that has occurred and where we are now, that's fine, except that then she doesn't make it very long once the conditions are put in place and she's drinking.
She does admit that she drank while on bond, Your Honor, and does take full accountability for that and does apologize for that. It is my understanding, I can't make the representation for sure, but it's my understanding that since this alleged offense in 2018, that there has been no further similar type of conduct. I don't know that for a fact. That is my understanding. However, she does acknowledge that she did violate her bond in this way. I'm asking that she be released today. I believe her to be put on the scram tether, and that she can come back for an adjourned pre-trial date to prove her or show that she does take her compliance seriously to the court. She was always very honest and communicated with me and wanted to take full accountability for her actions. And she did turn herself in this morning on this warrant. And she is asking if the court would allow her to be released.
Right, but wasn't she on a scram before?
Well,
so, all right. I mean, I'll hear you out, counsel, but I don't know. Why would I release her under the same conditions when in very short order she had violated why would I do the same thing again?
I understand the court's concern, Your Honor. Ms. Conrad, this was a wake-up call getting this warrant. She takes it seriously and did turn herself.
It wasn't a wake-up call just being present in court telling you not to drink?
Your Honor, I believe this was a harsher wake-up call. And I would just ask if the court would consider letting her out and giving her a chance. And I completely understand and Ms. Conrad is fully aware, if she were to violate in any capacity again, in all likelihood, her bond would be revoked until the pendency or till the end of this case.
How did she get here to turn herself in?
Pardon me? How did she get here to turn herself in? I don't know for a fact.
Can I speak? I'm sorry.
How did you get to the jail?
I was dropped off. My roommate.
Your Honor, her roommate dropped her off at the gym.
May I ask a question, Your Honor?
Sure.
The violation report the court is reviewing, is that dated October the 4th?
I do have an October 4th report. That's the one that I'm looking at.
I was confused because when I review this, it says on the second page that the defendant denied alcohol consumption. It's like he used cough syrup.
I know.
Okay, I'm sorry. I wanted to make
No.
I had read it differently in court, so I was concerned that there was a revised report that I hadn't received.
Correct.
We'll let the court know as well. There is a 2010 prior offense, so this is at least the defendant's second.
That is correct, Your Honor. She admitted to her first violation of drinking a glass of brandy to community corrections, and then did admit to consuming cough syrup, which technically usually has alcohol in it, and they're provided at community corrections that they should not
Did she
consume.
really drink cough syrup?
Yes, she did.
You did?
Yes. Well, actually, it was Alka-Seltzer plus.
So what are we doing on the case?
I'm asking for an adjournment, Your Honor. My office has not yet received media discovery in this case. I have requested it from the people.
Both of our cases will be adjourned. November 5th, 2025, 9 a.m. I'm just, so it's really two violations all at once. In essence, I mean, because it told her not to drink, she drank. Right? And then I guess presumably then has cough medicine that she can't have while she's on bound. And they go through, you hold your hands up like you didn't know that. They go through that with you. You can't have anything that has any alcohol.
Your Honor, we are not at all skirting the first violation at all, the alleged one, and Ms. Conrad states to community corrections and to me that she'd consumed liquor brandy on that day. My client is telling me that the report about the cough syrup allegation, and I understand what Your Honor is saying, and I do understand that community corrections provides that information. Ms. Conrad is now telling me it was Alka-Seltzer Plus, and she did not know that that may have alcohol in it. But she does acknowledge that first violation, her very first one, and she was immediately honest with community corrections.
Yes,
In the water?
yes.
That's not cough syrup.
Cold medicine. I said I took cold medicine.
Your Honor, my client is stating to me that
I question Ms. Conrad about the alcohol detection. She denies consuming any alcohol and states she used cough syrup.
Cold medicine.
Your Honor, my client.
So now you're saying you said something different that's in the report?
I'm saying I said cold medicine. I didn't say cough syrup. I said cold medicine.
So you're saying, but you denied consuming any alcohol, but now you're telling me that, huh?
I never denied consuming alcohol.
Your Honor, I believe
brandy-
she's referring to the brandy
Oh.
event that immediately she did admit that she had
Yes.
consumed liquor on that day.
She says. It says here, I question Ms. Conrad about alcohol detection. She denies consuming any alcohol. She states she used cough syrup. Where's her admission to the brandy?
On the first page, Your Honor, it states, I questioned Ms. Conrad about this alcohol detection, and she admits to drinking a glass of.
On the, right.
That was after the first alleged violation. On
Right, and then there's another one.
30th.
And so on that one, she says she wasn't drinking
Correct.
and that she had Alka-Seltzer Plus
That is correct, Your Honor.
or something in water that
Stuff.
Your Honor, ultimately, Ms. Conrad completely acknowledges she drank brandy. And that was
on the one day.
Right.
But here's the problem. If you're an addict and you're telling me on one day, yes, I did it because I got caught. But then comes the next time and you start going through what is the natural thing for most addicts, a denial. Saying that everybody got everything wrong. I didn't have any alcohol. It's coughs. I had Alka-Seltzer Plus. So you're saying Alka-Seltzer Plus came up as a positive?
I can't speak to that, Your Honor, but what I can speak to is that Ms. Conrad was enrolled on this in September 4th. She had a drinking event on September 30th. This was her first contact from community corrections about the drinking event, to which she immediately admitted to drinking liquor. She didn't try to make any excuses or say that it was cough syrup, cold medicine, or anything. She was 3 weeks into her bond, just shy of 3 weeks. She drank, she violated her bond. She takes full accountability to that with both the court as well as to community corrections. She did then have another event that the Scram Tether picked up on October 3rd. She states to me that she, yes, agrees with that part of the report, that she denied consuming any alcohol. She states to me that she told community corrections she took cold medicine. And of course, if that had any alcohol in it, she would not be allowed to do that as to bond, which she now understands. She does admit to drinking
But she's
while on
telling me it's Alka-Seltzer Plus.
as to the second event, yes, Your Honor. And she admits to the first one in complete
Okay, I'm
honesty.
gonna let you go ahead because I'm about so done right now.
She's taking accountability for the bond violation, Your Honor, and she's asking that the court
She's
release her
taking
today.
half accountability. She's not taking full accountability.
So if I say I drink alcohol, will it make a
So here's what I'm gonna do. I'm gonna adjourn this to November 5th, 2025, 9 a.m. for a sentence on her violation and pretrial. Her bond continues as denied. Thank you. Court calls the case, People versus Jeffrey Ostermiller.
Ash Feltus for people. Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Oscar Miller. Your name, sir?
Jeffrey Ostermiller.
Thank you.
I am requesting an adjournment. Mr. Ostermiller got me a lot of mitigation materials, of all the good stuff he's been doing. I just want some time to get that over to people.
November 19th, 2025, 9 a.m. Bond continued. Court calls the case, People versus Devontae Connor Belcher.
Ash Feltus for people. Does you two cases?
I do.
Assistant Public Defender Natalie Pate on behalf of Mr. Connor Belcher stands to my right. Please state your name for the record, sir.
Devontae Connor Belcher.
Thank you.
Thank you, Your Honor. I have two brief requests. One, as to the pretrial, I'm asking for a brief adjournment. I had the opportunity to discuss these cases with Mr. Connor Belcher, and he has proposed a type of resolution that he would like me to speak further with the people regarding both of these. And I'd also like to briefly address bond when appropriate.
Adjourn both matters to November 5th, 2025, 9 a.m. as to bond.
Thank you, Your Honor. As of yesterday, the only matters holding Mr. Connor Belcher in the Washtenaw County Jail are these two matters. These are both retail frauds, and the bonds are currently set at 1,010%, as well as a third matter, which is disorderly out of 15th District, that the bond is currently set at 1,010%. I still need to contact the public defenders in that court regarding the
People
bond.
don't have any objection to a PR bond?
Leave it discussion of court.
So that's
Yeah, anything else you'd want to say?
No.
Good. Bond will be reduced. $2,500 personal recognizance bond. Don't mess it up.
Yes.
Hey, come back when you're supposed to. You hear me?
Sir, of course.
All right. Thank you.
Thank you, Your Honor.
He doesn't show back up. I'm taking you in, Pate. Shondell Barrett.
Good morning. What was the name? Oh, Barrett. Ashley Feltus for the people.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Ms. Barrett.
Ms. Barrett, can you state your name and turn on your camera, please?
Barrett.
Well, she works on getting her camera on. Oh. Bless you. All right. I don't know what's going on.
Well, Your Honor, we are requesting an adjournment for plea negotiations.
Adjourn this matter to November 19, 2025, 9 a.m. Bond continued. Thank you, Ms. Barrett. When you come back on the 19th, know how to work your camera. Court calls case, People versus Ishmael Davis.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Davis. State your name for the record, sir.
Ismail Alexander Davis. All right, what are we doing?
Your Honor, I guess two requests. The first is an adjournment of the pretrial, as I am, we are in negotiations. And the second is in order to release Mr. Davis to treatment.
The
Mr.
court will
Davis,
sign that order if,
I do have it's non-stipulated. I don't want to speak with Ms. Feltus. She said she'd leave it in the court's discretion. I don't.
all right, then I'll sign the order.
Okay.
I'll grant your motion. Adjourn this to November 5th, 2025, 9 a.m. And I've signed the order for release to treat inpatient treatment.
Thank you, Your Honor.
Thank you. Oh, okay. Court calls the case, People versus John Neary.
That's focus for the people.
Assistant Public Defender Natalie Pate on behalf of Mr. Neary, who stands to my right. Please state your name for the record, sir.
John Neary.
Thank you, Your Honor. Make the prosecutor and I approach.
Okay.
Thank you, Your Honor.
7. Our record should reflect we've had a bench conference in this case. I'm going to, counsel's explained to me some things, Mr. Neary, and just with you and your family the best. Okay, sir?
Yes, sir. I appreciate it.
I'll adjourn this to January 7th, 2026.
Yes, sir.
At 9 a.m. And the reason I remember you remember our last interaction when you first came in, Mr. Neary?
Yes, sir. I was,
You
I was
remember?
on the deer hunt.
Uh-huh.
Yes,
No, you
No,
were.
no.
I didn't know what you were gonna do. You were like kind of angry and just telling me you were a hunter, and I'm like, okay, I get it.
No.
No, I get it.
I'm
You,
hungry.
no,
I'm
you
hungry.
started out. Hold on. No, I remember because when I saw you, out of
Well,
all those people,
I trimmed my beard.
I
trimmed my beard.
yes, you did. But I recognized you. I said, that's him. That's
Yes, sir.
And so I was trying to figure out a way I was going to do this. And then it was bow season. And I said, okay, we're going to let him shoot with bow. And
Yes,
then
sir.
I remember the only thing that calmed you down was me telling you were coming back on the opening of firearm season and I'd address it then. Then you said, okay.
Yeah. I won't be doing it this year, though. I mean, I've got prior.
Well, yeah, and I understand why. And again,
Yes, sir.
be in our thoughts and prayers. All right, sir.
Yes, sir. Thank you.
What I am going to do is, I know you got more important things to take care of, but because sometimes while you're doing that, you may need a break. All right. And maybe you won't, but maybe you do. So what I am going to permit is I'm going to permit him to possess a firearm in case he just wants to go out and just maybe clear his head.
My wife's more important now.
What?
The wife's more important.
Oh, I know.
That's what I gotta
But
do.
sometimes maybe you just need to
Mentally.
clear-
Yes, sir. I understand.
So I'm
Mentally,
just,
yes.
you don't have to do it. I'm just allowing it.
Yes, sir.
Okay.
I deeply appreciate it. I really
All
do.
right.
Thank you so much.
You take
Thank you,
care of
sir.
yourself and,
Okay.
give your wife my best. I haven't met her. But
I will do it. I will do it. Thank you,
all right,
sir.
Thank you, Your Honor.
Court calls the case People versus Brandon Nash.
That's focus for the people.
Your name, sir?
Brandon Nash.
Good morning, Your Honor. My name is Sam Fisk. This is my partner, Melanie Lemus. We're student attorneys with the University of Michigan.
You're kidding.
We are not.
You're kidding. I'm shocked. They're student attorneys, Alan. No, go ahead.
We are requesting permission to practice under MCR 8.120 under the supervision of Sarah Sal.
Good morning, Ms. Alan. So, hold on. You haven't spoken before?
Not
You
yet.
did all the talking, right?
Yeah.
Why?
He was in class.
Is he? Oh, he was in class?
And he was scared.
Oh, that's not what she said to me. She said you were going to mess it up.
I have tremendous
Oh,
faith
okay.
there.
That's why he's not here. Where are you from, young man?
I grew up in Hartford, Connecticut, sir.
Connecticut?
Yeah.
Where'd you go to undergrad?
I went to Claremont Mechanic College, Your Honor.
Yeah, how's that? I mean, where's that?
California, Your Honor.
So you left Connecticut, went to California,
Yes, sir.
and now you're here.
Yeah, I lived abroad for a year and now I'm here. So I took the scenic route.
Lived abroad where?
I was at the University of Cambridge, Your Honor.
Excuse us. See that? How he just threw that up in there. I was abroad. He wasn't going to say why.
Candor with the court, Your Honor.
No, that was good. So you went to Cambridge. You started in Connecticut, went to Cambridge. Well, then California, and now you're here. So when you're done, you're not going to stay here.
I'm going back to California, Your Honor.
So why don't you just go out there?
I got into Michigan, Your Honor.
That's not a big deal. Anyway, speaking as a Maryland grad. All right, permission to practice is granted. I'll let you go ahead.
Thank you, Your Honor.
On behalf of your partner, don't mess this up.
Fingers crossed, Your Honor. This morning, we're seeking an adjournment.
Yes, go ahead. Why?
Well, we're still waiting on discovery in a case with a common nucleus of facts. So we're waiting to hear from the
What?
other
Did
attorneys
he
in
do
that
some
case.
Latin there? What did you say?
From a very related case, we're still waiting on discovery.
What? No, what word did you use?
Common nucleus of facts.
Garen, did you know what he meant?
Couldn't understand words.
Yeah, I didn't get it. He might as well have done it in French because I wouldn't have understood what he was talking about. Oh, so common nucleus. It's like I'm in a science class. All right, fine. So you're waiting on discovery on that.
Yes, Your Honor.
From where?
From the attorney related in the felony matter.
Oh. Is it the public defender that's representing him on the felony?
I believe so, Your Honor.
No. He got it wrong.
Oh,
He
okay.
got it wrong.
Apologies.
See,
Yeah.
selling back there. So you're just waiting to get some information.
That's correct.
Okay, so how much time would you need? She is so thankful she's not up today. How much time did you need?
We would be interested in working towards the final settlement in December, if that's possible. We believe the next one is on Friday or so, and we think that the final settlement in December is appropriate.
Wow. Sal, is there anything you want to say on this?
If we are hoping to resolve these matters short of trial, I would recommend adjourning pre-trial rather than proceed to final settlement conference.
So what do you want to do? Don't look at her. You're up. She had to do it on her by herself and did a fine job.
We believe a 2-week adjournment would be appropriate.
So you can do it by November 5th? Or do you want November 19th?
More time would be better, Your Honor. So November 19th.
No, you don't even know that. Miss Sullivan, what day would you be available? It was the 5th or the 19th. Boy, oh boy, he's just, you want to know why it's that Cambridge education?
Your Honor, the 19th would be preferable.
Thank you. Will that work with you?
Yes, Your Honor. Thank you.
Of course, you're a student. You're not doing anything. Nash, don't get nervous. You're in good hands. You good?
I like you.
Huh?
I like you.
Him?
Love the sense of humor. You.
Oh, me?
Yeah.
Oh, yeah. I like me too. What do you think about him? No, don't say it.
Your Honor, additionally, we'd like to request a Zoom proceeding if possible. Brandon has to travel 2 hours from Kalamazoo for these proceedings. And it'd be easier for him if we could do it remotely.
Okay. We all know how that's done.
If I may, Your Honor, you wanted him to be present in court?
That is correct. So, but I think that was because of his testing.
That's right.
And I'm a little bit worried about that. I'll get to that. November 19th, 2025, 9 a.m. as your invite indicates. I'll adjourn it to that date. Do I have new test? I have October 8th. He's got results pending on his EKG. Do you have a medical marijuana card?
No, sir.
And why do I have THC in your system?
Yeah, honestly, I was a heavy smoker, but when you said don't smoke no more, I did not smoke. I was calling the drop line every day and my levels have been coming down.
It's London.
Defendant is on parole.
Got it. That's right.
We had come, I think the court calls now, we had come and we had talked about him being an absconder at the time that he picked up 2 retail frauds in Washtenaw County. And the court very graciously has given him PRs in this case as well as the felony, which is not before the court today. But that's of great concern to the people.
But my understanding is he was on it, but I thought his absconder status, he's rectified that issue.
That is correct. But I still think he's on parole at this time.
Is that correct? You're still on parole?
Yes.
And you can't use while you're on parole.
Honestly, they don't test for marijuana on parole. But when you told me to stop smoking, I stopped. And my levels came down, like you said, last via Zoom, and I'm just on the right path, honestly.
All right. If you submit the proper paperwork, I'll allow a Zoom proceeding, provided I don't get a positive test. If I get a positive test, you're going to need to be here. Understood?
Yes, sir.
All right. Anything else?
No, Your Honor. Thank you.
Sure.
Positive.
Is there anything else? Or is, no, I'm asking you. You know what's going on. Is there anything else? No. Is he good? All right, we're good. All right, thank you. I'll continue. That's okay. He's from Cambridge. Court calls. Don't talk to him. Court calls the case. People versus Christopher Minor.
Conrad Solar on behalf of Pittsfield Township.
Aaron didn't step anywhere near that. I don't know what that.
Catherine Mann on the record in BU 2025 TR 1700. State of Kansas versus Catherine Lynn Mann. Jared Regier for the state. Catherine Mann, you want to start your audio and video, please? Catherine Mann?
I'm here. Sorry, my phone was having a hard time connecting.
All right, well, Miss Mann, you're here on 1 count of driving while suspended, a Class B misdemeanor. If convicted, your sentence could be a fine of up from $100 to $1,000 and up to 6 months in the county jail. Are you interested in the diversion that you've been hearing about this morning?
Yes, ma'am, that would definitely interest me, and to update you guys, I'm currently been trying to get that resolved with obviously the suspension. I had the police officer falsify the BAC level, so I'm currently now having to go pay my storage unit hopefully today. I'm hoping I can get all the funds for that and then dig through all the paperwork because my BAC level was 0.12 and or 0.012 or whatever, and I have hypoglycemia. So legally, from what the attorney told me, is he wasn't supposed to breathalyze me and actually do a blood test because of that. And I just found out I was unaware hypoglycemic like 2 months ago. So I'm just trying to find that because he then wrote that it was a 0.126, which obviously that's a big difference. So I've noticed a couple people like that were in court that had the same BAC levels as well. So I'm just trying to protect myself and at least try to get that paper, and I'm hoping nothing got damaged during the move. But I was dealing with some domestic violence and got myself out of that and now in a hotel. But I'm just trying to make it through with 3 children and a dog. So I'm I'm just doing the best I can, and I do apologize. I haven't been able to just get this done right away and just send the information towards Destiny. So
All right, I had, yeah, when I printed my list, okay, we only have the one case on Catherine Mann, that's 25 TR 170. But then I see there is on her Odyssey record an El Dorado 2025 TR 1796 pending. But that's driving while suspended as well. I don't understand where your BAC comes to play in this. Are you saying that that's why you were suspended, was a DUI?
yes, ma'am, it was a DUI, and I with the other account that happened in Kansas, that was on my way towards Oklahoma to see we'll have my daughter see her father for 4th of July. And obviously for my very first road trip, I got a ticket on the first day and hit a deer in Burlington in Colorado. And then obviously was just hating myself for ever driving there because I didn't know that I had a suspension. And then obviously once I was aware, I was just trying to get home. And obviously, thankfully, the officer did let me leave and didn't impound my car or imprison me. But it was obviously due to the fact that I had my daughter with me that there was some leniency. And I do appreciate you guys for giving me that opportunity because I was just trying to do this for her father. And now, obviously, I will never do that again. You guys will never, obviously, once I got back into Colorado, like I have been just using metro buses and using rides from friends. And it's been really hard until I can get that paperwork. But I obviously, due to the not being able to work like I used to, I am not really able to like get
Ms. Flynn,
things taken care of.
I'm gonna kind of draw you back into the matters at hand that may or may not be related, but right now we have limited purposes for being here. So you said you have a DUI in another state that got you suspended and you're challenging that right now?
Yes, because the officer falsified the BAC level.
Okay, did you say you have an attorney looking into that or not?
I have an attorney for that, yes. But that was a court appointed one.
And are you saying he falsified it or he just didn't take into consideration that you were diabetic?
He falsified because there's two different BAC levels, and then he wrote two different speed because he originally pulled me over for speeding.
Okay, let me stop you there because again, we don't need to take that all up today. Are you going to apply for an attorney in this case or hire an attorney or waive your right to an attorney?
I would like a court appointed attorney if
let's see if
I
you
can't do
qualify.
am I not still doing the diversion? I'm confused. I'm just
Well, if you have two driving while suspended pending and you have a DUI in another state, I don't see it on your Kansas court file, but
well,
if
it's
it's in,
because it's in Colorado and I'm currently like fighting for that. So that's why
all right,
it's probably
okay,
doing that.
well, I don't see that you're going to probably qualify for diversion. You can look into it, but I don't expect you to probably qualify.
I mean,
But
I know at least the other location, they're giving me that opportunity. So I was just truly hoping that you guys could do that for me at least.
well, you and your attorney can look into that unless you don't want an attorney. But do you want a court appointed attorney or do you want me to ask you about
Yeah,
that?
I would need a court appointed
All right.
attorney.
Okay,
I'm
slow
on
down.
ABT and WIC, so
Okay, slow down. How much money do you make per month?
I make only like $350.
And do you get that from the state? Did
I
you say?
get from the state, I only get I think 250.
And is that in food stamp assistance or?
That's
food card?
cash assistance. And
You
then
get
for
cash
food stamp,
assistance.
I don't know what that exactly is. I think it's like roughly around like 400 or something like that. It
Okay,
just
well, hang
significantly
on.
dropped.
Do you, in addition to the cash assistance and the food assistance from the state, do you have a job that gets you any money?
Holistic healing and online creating. So and that doesn't make much. So,
How much per month do you get for this holistic healing job?
I have not been currently being able to book anybody, so currently $0 for that, and for anything online, it's only about $250, if not $350.
What do you do online? You make things and sell them?
I do OnlyFans.
Okay. All right, so $500 a month, and how much for rent do you pay?
I'm paying $418 for the hotel, a week.
So you stay in a hotel, okay, and that covers your electricity and so forth. And did you say you have a child also or not?
I have 3 children and 1 dog.
And who supports them?
Myself and a little bit of their father.
Mm. I'm going to find that you do qualify for court-appointed attorney. I will appoint attorney Darren Patterson. His number, are you ready to write it down?
I'm trying to think of where my pens are right now.
Always, everyone, bring a pencil or pen to court. Always.
I'm just gonna go and text it to myself.
All right, are you ready to text it to yourself?
Yes, I am ready.
All right, now then, Miss Mann, you need to call Mr. Patterson as soon as the court is over and get set up to talk to him about your case. But you need to also go into a breakout room with court security too. Deputy, that's what you're showing, right?
Yes, Your Honor.
And Your Honor,
Mr. Regier,
the state does wish to be heard on the issue of bond at the appropriate time.
this is appropriate. Go ahead.
Your Honor, in addition to the statements made on the record today, it would appear that this is a defendant who, pursuant to the ticket in this matter appears to refer to an address outside the state of Kansas. Additionally, if the court is prepared to accept a proffer, it would appear that in Ellis County District Court case number 25 TR 1796, there was a prior failure to appear pursuant to a journal entry of first appearance. Looks like that was back in August of this year. Therefore, the state is recommending a $3,000 bond. State has no objection to an OR bond.
All right, I'm gonna, Miss Mann, you need to put your camera back on.
Okay.
All right, Miss, I'm gonna
And
set
that
your
was
bond.
currently because of the domestic violence that I was dealing with, and I showed the documentation to that the county so that they could take care of it and obviously give me a new court date. So I resolved that situation.
All right, so I'm gonna set your bond at 3,000. You're not gonna have to put the cash up unless you fail to come to court, and then you'll owe that to the state and have a warrant for your arrest. So make sure you're here at that date that I gave you, or I'm going to give you, which is when.
So you guys are making me come physically now.
Okay, stop right there. We're not doing anything to you, Miss Mann. You brought this
I'm
on
asking a
yourself.
question.
You brought yourself on this yourself, or perhaps the officers did lie. That will be determined at a later date. But I did not go out looking for you. No one in the state of Kansas, other than perhaps officers enforcing traffic, went out looking for you to drag you in here. Now, if you want an attorney, I'm going to have to give you time to talk to that attorney. Why give you an attorney if you don't want to talk to him, if you want to take care of it all right now? You see why I need to set this over?
I'm not sure you're actually understanding what I'm asking. I'm asking if I need to physically come into court, like Kansas, or if I'm doing Zoom still. I'm not asking for anything else. I'm not asking for a lawyer. I'm just literally asking if I'm coming to court, because you guys are saying I'm having an OR for 3,000. So I'm just trying to comprehend this so I don't miss anything.
Okay. Do you or do you not want a court-appointed attorney?
I already wrote down the number, so I thought that was what we're doing, so I'm really
I'm
confused.
asking you a question. Let's
Yes, I
unconfuse
want a
you.
court-appointed attorney. That's what I thought we were doing. So that's why I'm really confused.
Okay, that is what we're doing. I did appoint Attorney Darren Patterson, and I gave you his number. But if you want him, we have to set this over to another date. And I was getting ready to ask Destiny what date she has for you to come back. Where can you fit her on the schedule, please, Destiny?
Your Honor, I have December 29th.
December what?
29th.
Miss Mann, please don't talk over her because I can't hear her. What was it? One more time.
December 29th, 29, Your Honor.
Okay, December 29th, 2025 at 8 a.m. You must be back here by Zoom, Miss Mann, like you are today.
All right.
Is that a big
Yep,
inconvenience?
December 29th at what time?
8 a.m.
8 a.m. So it'll be 7 a.m. in Colorado, right?
I don't know. You tell me. I don't know what time you are right now.
It's 9:34. So what time is it there, ma'am?
10:34.
All right. Thank you so much.
All right. Well, hopefully that won't be too big of an inconvenience for you. But if it is, you still have to live with it. Now, this is a part you're definitely not going to like because Kansas law says that anyone charged with an A or B misdemeanor or higher, which are the felonies, must be fingerprinted and have their photo taken. So you're going to have to come to do that at some point. Now, the officer will work with you on when you do that. And you will have to have a $3,000. Is that what you recommended, Mr. McGee? A $3,000?
Yes, Your Honor.
A $3,000 bond. You will not have to put the money up, but you will have to get your picture and prints taken. And you have to sign a bond acknowledging that you know if you fail to come to court, that bond can be forfeited. You could end up owing a judgment. You won't put the money up, so it'll be a judgment basically to the state of Kansas, and you'll have a warrant for your arrest. So does that confuse you, or does that make sense? Do you
No,
understand
that makes sense because that's what Ellis County had told me to do. That's what I did with Ellis County. So am I able to do fingerprints here at my location, like nearest to me in Colorado Springs?
I don't believe so. You'll have to check with the deputy, but I'm going to order that you do it in person so that they know the person given the fingerprints is in fact the person that says they're given the fingerprints. I have not found a way around that.
Well,
So
I mean, I don't know how Kansas works, but I mean, we just go to the police department and they have the scanners, so I don't really know how else they do it there. So
Well, I will say the officers to have my authority to do it if it can be done. Otherwise, it's my order that you do it in person if they can't work it out between the Colorado and the Kansas agencies. And I don't think they can, but that's where we are on it.
because currently they're not wanting me to leave the state, so I'd had to get permission to do that, even to do that. So I would
Okay,
have
so
to
let
make
me see
sure
if I
to.
understand. You live in Colorado,
Yes,
but you
I
have
was
typically.
visiting Oklahoma for my
Stop.
daughter's father.
All right, so you live in Colorado, but you came through Kansas on your way to Oklahoma where your daughter's father lives.
Yes, for 4th of July.
All right, and you got a DUI. Was the DUI in Ellis County out west?
No, the DUI was in Colorado Springs, El Paso County.
All right, so you got a DUI in Colorado, and is that the one that you can't leave Colorado on?
Yes, ma'am. I would have to get permission if that was the case, if I had to go physically into Kansas.
Okay. Are you on probation in Colorado?
I am not on probation. They have not made that. And more than likely, they would probably do unsupervised because of me being in intensive probation. Because of other things that have happened to me in the past, from domestic violence, having my jaw shattered apart from a shotgun in October 10th of 2018. I have been in group homes and foster care, so I was in intensive probation due to that, so that the probation officer can be able to give me the best resources to be able to
Okay, well,
not
I don't need all of
reoffend.
that. Thank you. I don't need all of that. but I just want to make sure I understand what kind of a risk you may or may not be on bond. So you live in Colorado, you're on bond in Colorado that says don't go out of state. Is that correct?
Yes.
So you'd have to get permission from your Colorado judge to come here to give your fingerprints and sign your bond, right?
Yes.
Okay. And then you got a driving while suspended in Ellis County that's still pending, and you have a driving
Yes,
while
they're giving me a
suspended,
diversion right now.
and you have a driving while suspended here pending. And then did you say you got into some issues in Colorado or in Oklahoma or not?
No, I was very well, once I got to his house, I made sure that I was only being driven.
You were what? I'm sorry, I heard someone
I
else.
was only being driven by the father and their family. I was not letting myself make more of an ignorant decision. I was just trying to let my daughter see her father because he hadn't seen her for months, and I felt really bad, and he was going through stuff. And so I was just trying to be a good mother and like a good person to him. So I obviously got in trouble for that, and I will never make that mistake again. So I'm just trying to get everything taken care of, and that's why I said I had to go through a storage unit after all the domestic violence I went through. Like, and
All right,
obviously
hold up. Okay, so you were violating a protective order down there in Oklahoma. Is that what they charged you with, or they didn't charge you with anything in Oklahoma?
I was never charged in Oklahoma with anything. I never did anything wrong in Oklahoma.
Okay, all right. So we got that clear. Mr. Regier, was there anything else you wanted to be heard on?
Nothing further, Your Honor.
I am going to set the bond at 3,000 OR since she showed up today by Zoom. She can show up by Zoom at the future hearings. You must contact Darren Patterson and tell him your court date and your contact information so he can help you. And then go into the breakout room as soon as I'm through talking to you. You'll get an invitation to breakout room on your screen. Click on that, go into court security 2 with the officer and set up a time to do your picture and prints, and then call Mr. Patterson in that order.
Okay.
All right, so be it. Anything from either party?
Not from the state, Your Honor.
All right. Thank you, Miss Mann. Look for that breakout room.
This is the state of Kansas versus Charlene Renee Smith, case number 2023 TR 3203, where Norris again appears for the state and Ms. Smith appears at the detention facility Zoom location. Several things about your docket notes disturb me, Ms. Smith. Number one, this is a relatively low-level traffic case, and you've already had 5 previous court appearances on it with nothing apparently being accomplished.
Well, we were trying to.
Just a moment.
Oh, I'm so sorry. I'm so sorry.
My second concern is failure to appear on
I
October 6th.
apologize. I take care of my dad, and my mom died and my dad has cancer. We just got through it. I had my dates mixed up. I had it on the 16th. I've taken the traffic driving course. I paid $400 so far. I have been trying very hard. I'm asking for mercy on you because like I take care of my dad. I'm his caregiver. If there's a way I could bond out, I will do whatever it takes.
Okay, Ms. Smith, there's nothing about the record of this case that indicates that you are trying to take care of business.
I have been on a diversion.
Okay, just a moment. Is there a current diversion process in the works here?
That's what we're hearing. That's who they wanted to combine. I got 2 tickets in one night for driving unexpired. On the way home, I hit a deer and got pulled over. So she went ahead and combined the 2 tickets. She had 2 separate cases. I've been going for the first one, I was on diversion, and then the second one we were still getting to. It was just being, then last one we went to, she was gonna combine the 2 tickets. So that's the one we were gonna discuss this last week when I had the dates wrong. And that's why I made sure to turn myself in when I found out that I had the date. I thought it was the 16th. it's my own fault. I mixed it up with another
Okay.
appointment, but we were fixing.
No valid driver's license is the charge here. I don't know why you'd be driving around without a valid
It
license.
was
That's
a
the
bad judgment
accusation.
call one night. I made a bad mistake and I got pulled over twice. I hit a deer. I waited till the morning to drive home and then I hit a deer and got pulled over again.
All right. Ms. Norris?
Judge, there are notes in, we only have one case. There was a speeding ticket, but that's, looks like it's.
I've been trying very hard. I took the diversion. I took my driver course. I paid
Okay.
$400.
I want to give Ms. Norris an opportunity to finish.
Oh,
Is there
I'm so
anything
sorry.
else
I'm sorry.
regarding this case? What
I'm
its
just
status
very.
is? She says she's paying on it, maybe a diversion in the works. I don't.
Your Honor, there was a diversion in another case, which was speeding case. And there was a motion to revoke diversion actually filed in that case, and she's supposed to pay it by, looks like December 22nd of this year. But if I guess state would agree to that, the court granted the motion to revoke diversion because she didn't show up on this October 6th date. The case that's in front of this court, she said something about wanting to apply for diversion back in June. She got Mr. Patterson appointed in July, and I don't see any paperwork regarding a diversion per se in this particular case. But she does have Mr. Patterson appointed. So I don't know if the court wants to set this on Judge Lee's Friday docket, or exactly how the court wants to proceed.
All right. So there is no diversion application in the works, apparently.
Well, we were going to ask for it. We were still on the other one. She hadn't got to the other ticket yet. And Judge, I have to try to take care of my dad, and I need to find out if there's any way you can get me home. I'll do everything you want me to do. I'll do what it takes. I have been following through. These are two
Okay, Ms.
tickets
Smith,
in one night.
those who have to care for others have, I think, an even greater responsibility to make sure they conduct their own business so things don't happen to them like it's happened to you.
Absolutely. And I dropped the ball. I have been working on this, and I have been talking to Regier's office, and I have been doing, April 16th was when I did the driver safety course. I did that. I was trying to get my license back because I do need to drive my dad to doctor's appointments. I missed this appointment, and it is very irresponsible, but I need to take care of my dad. I promise he's a veteran of 30 years service. I live with him. I take care of him. He's 85. He just got through prostate cancer. I'm just asking, I'll do what it takes with this case if I have to house arrest to get home, but I need to be home. He can't get through each day without my help. And I will follow through on everything. I was confused on the case because there was two tickets in one night and they were separate. This last time she was talking about combining them.
Okay, who is she?
Judge Webster, I apologize.
Okay.
I've seen Judge Webster. That's who I've been seeing this with these tickets. And Regier's office is the one who had helped me with my diversion. And like I said, I just missed this date last week, and I can't turn myself into the jail as soon as like I said, I found out.
All right, the court will reset this case for Judge Lee's docket November 7, 2025, 1:30 p.m. Defendant must fully participate in person in Judge Lee's docket at that time. Darren Patterson remains her counsel. Only matter left is her status between now and then. What is your position here, Ms. Norris?
Your Honor, it does appear that, let's see, initially there was a failure to appear in December. And then defendant appeared pro se in April. So She does have one previous failure to appear, which was the initial appearance. And it looks like
My mom did die and my dad just got cancer and I'm sorry. I'm just begging for mercy.
she'd previously been on a 1,000 cash or surety. I do believe a cash or surety bond is appropriate. I don't think that she really is a good candidate for an OR bond. But I do know that the current is no bond hold. So it would recommend cash or surety bond for this defendant.
Where do you live, Ms. Smith?
Pardon me?
Where do you live?
Here in Butler County with my father, like I said. Oh,
Address?
I'm sorry, 171 Southwest 100th Street. Here's Augusta address 67010.
What is the number at the start of that address?
171. It's Pickerel Corner.
Okay.
Oh, my parents had an old bait and tackle store.
All right, I'm gonna establish a new bond in this case at 1,500 cash or professional surety required. Remember, this is an independent order from any previous bond that was posted in the case. Again, the new bond is $1,500, cash or professional surety required. Court date November 7th. Judge Lee, Darren Patterson remains your counsel. You need to get these matters wrapped up, Ms. Smith. The more court dates you have, the more opportunity there is to miss court dates. Then you end up with warrants and being arrested and being in jail.
Thank you. I did it to
So
myself.
get these matters cleaned up. They've been pending in the system way too long. One way or the other. They need final resolution.
Thank you.
And you need to show up in court.
Yes.
All right. Anything else, Ms. Norris?
No, Your Honor, thank you.
Ms. Smith?
Thank you very much.
All right. Welcome. There's nothing further than the Smith matter is in recess. And I think that's the last jail case that we have on the docket.
Yes, Your Honor.
All right. Thank you.
Have a good day.
2.